Okay, Year 12 Global Politics. In today's video, we're going to be looking at the international laws related to people movement. And so there are going to be two international laws that we will be looking at. And the skill for this part is to analyse the international law. So we'll talk about what all of this means, and I'll go talk you through our two international laws for people movement. But before I do that, I kind of want to talk about some of what it says in the study design about international law. So international law encompasses a wide range of views that might be seen to govern the actions of states in international relations, such as treaties, declarations, bilateral and multilateral agreements, and even decisions made by bodies such as the United Nations. So they are rules that govern states, and they are guided by ethics, which is why states will sign up to them. In the glossary, it kind of goes into a little bit more about that. And I guess really the part that it goes more into is saying that, written legal agreements, such as treaties, are only binding to those who consent to it through explicit ratification. So ratification means that they have then taken it to Parliament and then to their national parliament, and they have all agreed that they will include this in their domestic laws. So Australia has implemented in their domestic laws, parts of these international laws. So that means that we actually have to follow what the international law is, or we have agreed at least, and we believe that we should be doing that. Some laws apply to states, such as the UN Convention Against Torture, while others may apply just to the citizens. What we need to remember about law is that their enforceability and effectiveness are different to international laws. So what I've got here is a few different quotes about international law. And the first one, I think, is kind of a pretty standard view of international law. And that is, it says, and covenants without the sword are but words and of no strength to secure a man at all. So basically, these international laws are just words. There's nothing to them there. They're not very important. It's just what it is. And a lot of students will say that about international law. They say that it lacks enforcement. States don't actually follow it. So, why do we have to do it? It's not very effective because, states break international law and it's just words. That is obviously partly true. However, international law is different to domestic law. So, what the second view kind of gives us another idea. It says that, the authors of these international laws have traded enforcement for political consensus. So states have signed these international laws not for enforcement, but more because the international community all agreed to this. So they've all decided that this was actually the right thing to do. And they've said that, because we don't have enforcement, we more have, popular culture, media and protests that name and shame states. So basically, we may have, these laws in place and they may lack enforcement, but states can be held accountable through other means and other methods. Often there is shame and there is, criticism from global actors when they do fail to uphold the international law. So this one, I think view number 3 is a good one as well. It says, as students of international relations, our default position is to assume that international law matters little to international politics. The power and the interests of states are what matters, and law is either a servant of the powerful or an irrelevant curiosity. If international law does not matter, why do states and other actors devote so much effort to negotiating these new legal regimes, enhancing or expanding existing ones, and conversely, avoiding legal commitments? Why does so much international debate centre on the legality of state behaviour, the applicability of legal rules and legal obligations incumbent on states? And why is compliance with international law so high, even by domestic standards? So I think this offers us a different kind of perspective, you know, and I think what I like about it is that it says, you know, if law does not matter, why do states devote time to creating it? And that kind of shows us that, you know, it does matter. States wouldn't waste their time if it didn't matter. You know, they obviously believe it because their ethics align with it, you know, and they go to the effort of then having to go to Parliament and getting it ratified. So, you know, we have to see law as being the ethical standard of what they want the perfect world to look like. And yes, states don't always do it, but they want, that's what you know, in an idealistic world, that's what we would all do. So, you know, it does matter because it does say what we would like everyone to be doing. What the final kind of view, I think, does well is it says, you know, the international law is different to domestic law. So it says, unlike domestic law, international law is not preoccupied with deterrence. It doesn't seek to punish states for their alleged misdemeanors as a warning to other states. And the fact that international law sometimes doesn't work because states sometimes breach it is hardly an argument even against it. Even domestic law is unable to stop a person who has decided to commit a crime. So, you know, it's still saying here that, you know, we can't just disregard international law because people break domestic laws. You know, it's sometimes laws aren't out there to punish states. It's more about, you know, the rights of what we should be doing and what we want the international community to look like. You know, international laws are important because that's why we bothered to create them to begin with. So that is maybe give you guys some ideas of how to perceive international law when we have to evaluate it. And with that, what do I need to know for international laws? Well, if you had to, you know, explain what's in the international law or, you know, discuss parts of the international law, there are other things you need to talk about other than just responses to the international law. So we need to know what are the features and protections of the international law. So this is when we can use articles, you know, and referencing the articles. You don't need to know word for word what's in them, but have a few that you can, you know, talk about. How do they address the issue of people movement or human rights? What are their limitations? How have global actors responded to the treaty? Has their obligations been reflected as they have as it was outlined in the treaty? And this is probably more, we'll talk about this in the next video about responses. So, you know, we will get to that. And then also below here, it's like, and to examine and analyse the effectiveness of responses by global actors and the extent to which their responses reflect the obligations outlined in international law. So we do need to make sure that we are linking responses back to international law. Okay, then it says in the 2019 exam advice, so when evaluating the extent to which international law governs the actions of global actors, consider the importance of determining the worth of an idea or concept when making a comparative judgment. So, you know, how effective are the international laws at governing actors? Take a position, have examples and contemporary case studies, make an evaluative statement about whether international law can govern the actions of global actors, and the impact of international law. Okay, I've given you a lot of background about these laws, so let's get into the actual law. The first one that we will be looking at is the 1951 Refugee Convention. It has 144 signatories and 145 state parties. So that means that they have 145 people have ratified, meaning it's in their domestic laws. It addresses the issue of people movement because it defines what is a refugee and it outlines what the rights are for refugees and the obligations that states have to protect them. So this is how the issue and how the convention relates back to people movement. So Article 1 is really the main article and one that has been actually implemented in domestic law in countries like Australia. So Article 1 defines what a refugee is. So a refugee is someone who is outside their home state and has a well-founded fear of persecution due to their race, religion, nationality, political views, or social status, and is not able to return home and rely on protections of their home state because of that persecution. So that's really the definition of a refugee. They have well-founded fear of persecution because of their race, religion, nationality, political views, or social status, and they can't return home because of the persecution. So persecution, I'd say, is really a key word here. That is what just makes a refugee, that they're being persecuted. So nowadays, though, this can actually be a bit limiting because we are now starting to see an issue where there are refugees because of other issues, such as, environmental reasons, climate change or poverty. And yet we can't actually accept them as refugee because they haven't been persecuted. So that's where the definition hasn't really been updated since then. We also have Article 31, which says that asylum seekers may enter illegally, but states should not punish refugees. So the key part there is we shouldn't be punishing people for entering. And Article 33 says legitimate refugees cannot be forced to return to a place they fled from, which is the idea of non-refoulement, that we can't send people back to where they will be hurt and tortured. There are other rights included in this convention, such as the right to housing, public welfare, education, the access to courts to obtain justice, the right to freedom of movement, right to work, freedom of religion, and the right not to be punished. So these basically are all these rights that refugees should have and are the legal obligations that states have to give to refugees. It's what they all, if you're a refugee, this is what you get. If you're being persecuted for the reasons of race, religion, nationality, political views, or social status, you can come and you can receive these things. So in terms of the, how this actually works and how it is enforced and how it is effective, well, the United Nations High Commissioner for Refugees is the body responsible for protecting and assisting refugees. They oversee states and try to ensure that states are complying with it, although they actually have no real legal, they have no real legal avenue. The UNHCR can't take states to court. So all they can really do is encourage states to actually do the right thing. So if you have signed, you have to participate with the UNHCR and coordinate and work with them. So in terms of how this has been an effective international law, well, there has been really a universal acceptance of non-refoulement, that we should not send people back to a place where they will be hurt. That has kind of been universally, not really universally, but has been accepted by the international community as being important. And the definition of a refugee in Article 1 has also been accepted by the international community. They have all agreed that if you are being persecuted for those reasons, that you are a refugee. And, in Australia, we have actually got this in our domestic law in section 5H and section 5J of the Migration Act. That includes the same definition as what was in the Refugee Convention. So that's good. However, the definition of a refugee has obviously changed over time. There's only 5 reasons that are listed here, but now we've got other issues such as poverty and climate change. And we are going to see over the next few years, groups of people having to leave their home country because they can't live there anymore. So we are going to have to come up with a way, or we may need to revamp the definition of a refugee, because at the moment it doesn't include those people. Also, an issue with this international law is that there's no enforcement mechanism to ensure compliance. Although it is legally binding, although we have the UNHCR to encourage states to comply, there's no mechanism for individuals to file complaints. So if an individual feels that their rights have been violated, they haven't been classified as a refugee, even though they are a refugee, there's nothing that can be done. The only way to hold states accountable is for complaints to be referred to the International Court of Justice, but the International Court of Justice is only available for states who want to sue other states, not individuals. And it's unlikely that a country is going to take another country to the ICJ over the Refugee Convention. So it does mean that there's no real consequences. What we have seen, though, is international shame through the press, verbal condemnation from the UN. That has been another way of holding states accountable. So, although there may not be compliance through this, we can still, states may be still held accountable with, verbal condemnation and, shame and in the international community. Okay, our next international law is the Protocol Against Smuggling of Migrants by Land, Sea and Air. This treaty came about, or international law came about more recently, and it has 112 signatories and 149 ratifications from states. So 149 states have all implemented it into their international law. The purpose of this law is to prevent and address people smuggling and to guarantee international cooperation for the protection of the rights of people who have been smuggled. So it's about, punishing the smugglers and protecting the people who have paid the smugglers to smuggle them. So about protecting people who have been smuggled. They have the people who have paid people smugglers to take them back, to take them to another country. What this international law also does is actually outlines what smuggling is and have tried to distinguish between smuggling, what the difference between smuggling and assisters are, or people that try to help. So they describe smuggling as being criminal when people are gaining some sort of financial or material benefit. So this is Article 6. So Article 6 says that smuggling only applies when assisting migrants to obtain financial or material benefits. So this is different from people being helped by families or support groups or non-governmental organisations who want to help asylum seekers and migrants. There's a distinction here. They are doing it to help people, whereas smugglers are being paid to take someone across and overseas. So that's really a really important part of this protocol, is that it actually defines what a smuggler is. They also kind of make it clear that smuggling is different to human trafficking. Human trafficking is when you're taken against your will, whereas smuggling is, a contractual or agreement, that you are a customer and you are paying a smuggler. However, there are obviously more abuses that take place, but you're paying them to take you somewhere, whereas human trafficking, there's no consent. You just are being taken. So Article 6 outlines there's a financial benefit. There is no enforcement mechanism here. All there really is international condemnation when you don't follow the international law. Article 2 outlines that, or says that we have to protect the rights of those that are smuggled and that we shouldn't punish them. So they shouldn't be held in detention centres, or they shouldn't be tried and convicted and sentenced. There shouldn't be a punishment for them. They do outline what a smuggled migrant means. The fact that you are entering into a contractual agreement with a people smuggler. They also, importantly, and this kind of goes back to the punishment thing, that it's not a crime to be smuggled. So, you paying someone to take you overseas is not a crime. What they are more focusing on is prosecuting the smugglers, prosecuting the people that are financially benefiting from this situation. So they're more thinking about that. Article 6 places rules on criminalisation. They cannot be into practice unless the state creates domestic laws that follow the protocol. And Article 20 says that states can make reservations, which means that states can choose aspects of the law that they are not bound by. So that's a way that people can avoid complying with this international law, is when they say, oh, but I don't want to follow that part. So that can be a little bit of a problem there. And if you are interested, you should look up the international law to see which countries have made reservations to this particular law. Often people just call it the Protocol Against Smuggling of Migrants. So it is fine just to call it that. And people sometimes just call the Refugee Convention, just the Refugee Convention. So you're fine calling it either of those things. I hope that video was helpful about the international law. If you have any questions, just ask. And thank you for listening.